Hi, I'm Tracy Murda, and I'm here with Utah family law attorney Kelly Peterson. Kelly, could you give us a roadmap of our discussion for today?
You bet, Tracy. Sometimes after a couple separates, the primary residential parent, the custodial parent, remarries. And simultaneously, the custodial parent screws up. They fade out of the picture. They don't stay connected with the child. They abuse or neglect the child. They become an unfit parent. And that abuse, neglect, unfitness, or lack of involvement significantly damages their relationship with the child. And during this time, the child develops a tighter bond with the step parent than with the non-custodial parent who's screwing up. And under those circumstances, in Utah, the custodial parent can petition the court to terminate the other parent's parental rights so that the step parent can then adopt the child.
What does the primary residential parent have to prove in order for their new spouse to be able to adopt?
There are two things they have to prove. First, that there are grounds for termination of parental rights. And second, that from the child's point of view, it's in the child's best interest for the adoption to occur.
Okay, so let's take these one at a time. What kinds of things would satisfy the grounds to terminate requirement? And then what kinds of grounds are we talking about here?
Grounds to terminate can include a number of things: that the child has been abused or neglected, that the parent is unfit or incompetent, that there is a likelihood that the parent will not be capable of exercising proper and effective parental care in the near future, that only token efforts have been made by a parent to support or to communicate with the child, if there are mental health issues that cause the parent to be unfit, if the parent is incarcerated for lengthy periods of time, preventing their ability to really be a parent, or if there are substance abuse issues, if a parent is harming a child by physical or developmental injury in some way, emotional damage can be included, sexual abuse, failure to properly care for the child, all of those things can constitute grounds for termination. One of the most common grounds for termination of parental rights, though, is abandonment, fading out of the picture, or even if they have other difficulties preventing them exercising their parent time, but they're not really doing what's necessary to overcome those difficulties.
So what does it take to demonstrate abandonment?
Abandonment is conduct on the part of a parent that implies a conscious disregard of the obligations that that parent owes to the child, leading to the destruction of a parent-child relationship. A lot of things can do that. If they fade out of the picture for a long period of time, such as no contact for a period of, say, 6 months or so, or having a lengthy prison sentence, that in and of itself can constitute abandonment. If a parent, say, fades out of the picture for a long period of time, except that they have maybe send a birthday card or a Christmas card and they text once or twice in the last year. So they maintain some degree of contact, but it's really just token efforts. It's not really maintaining a parent-child type relationship. That can constitute abandonment.
All right, let's say someone has grounds to terminate. What kinds of things would it take to show that from the child's point of view, it is in the best interest of the child to allow that termination and adoption to occur?
The court looks at the totality of the circumstances of the child. That includes the abuse, neglect, unfitness was, all the things that gave rise to the grounds. But the court also looks at the children's physical needs, educational needs, emotional needs, any special needs that they have. They look at the past conduct, the moral character of the parent, their emotional stability, if they're unable to function as a parent due to drug abuse, excessive drinking, instability, in housing, instability in employment. If a parent has relinquished their parent time or custody in the past, that can be a factor. The parent's financial responsibility or lack of responsibility can play into that. The court can also look at how happy and well-adjusted the child is now. If they're in a good situation, that's going to play a role. The court's going to look at the relationship between the child and the unfit parent or the abandoning parent and compare it with the relationship between the child and the step parent. When viewing all of those things from the child's point of view, the court has to be firmly fixed on finding the outcome that secures the child's well-being the best. Once grounds for termination is found, even if it's only one ground for termination, at that point, the constitutional right of that parent to raise their child, the parental presumption becomes rebutted. And then the only thing that the court has left to consider is what is in the child's best interest. The child's best interest takes precedence over everything, all other considerations. And so the court has to ask, can the child be equally protected and benefited by something other than adoption by the step parent? And if the answer to that is no, then the court's going to say, look, I think it's in the child's best interest to terminate and adopt. Let me give you an example of some findings that a court might make when finding that it's in the child's best interest to terminate. They might say something like this. For purposes of this example of what a court might say, Tracy, I'm going to refer to the parent whose rights are being terminated just as the non-custodial parent. And the court might say something like this. The non-custodial parent will not be able to establish and maintain a meaningful parent-child type relationship with the minor child within a reasonable time. That although some type of relationship exists between the non-custodial parent and the child, there's less of a relationship between the child and the non-custodial parent as there is between the step-parent and the child. And it's been that way for quite some time. By way of contrast, the child and the step-parent have a close, warm parent-child type relationship. The relationship between the child and the non-custodial parent is more of an uncle-dad or aunt-mom kind of relationship. It is a secondary relationship and is not as strong of a bond. That should the custodial parent die or become unavailable to parent for any reason, it would be contrary to the children's best interest for the children to be parented by the non-custodial parent rather than the step-parent. In fact, there would be a high likelihood that the children would be further traumatized by being removed from the step-parent and would be at significant risk of mental and emotional decompensation to be moved to the non-custodial parent with whom they have a lesser relationship. Bad consequences could occur psychologically, developmentally, should a child be removed from, say, a half-sibling or a step-sibling. So the value of preserving the lesser relationship with the children is outweighed by the value of preserving the parent-child type relationship that had been formed between the child and the step-parent. The children are currently happy and healthy and thriving and well cared for, not only by the custodial parent, but also by the step-parent with whom they have formed a parent-child type bond. So from the children's point of view, it's in the best interest of the children to terminate the non-custodial parent's parental rights and allow the step-parent to adopt, so that that relationship can be safeguarded. This course of action is necessary and would secure the best outcome for the child long term. Failing to allow the adoption cannot equally protect or benefit the child. That might be a type of ruling that a court might make in determining why it's in the child's best interest to terminate and adopt.
So Kelly, how does the case get started? Walk me through that process.
Okay, so first you file a petition and a summons, and there's a particular kind of notice to the non-custodial parent that you have to file and have them served with. If they don't file an answer or a response or move to intervene into the case after they are served with the summons, petition, and notice within 21 days or 30 days, depending on whether they're in the state or out of the state, then you can file a motion for their default. But let's assume that they file an answer. Then you engage in various methods of proving your case before to get ready for trial.
How does that one then go about proving grounds to terminate and proving that it is in the best interest of the child?
You can use a variety of methods to help prove this. If the child is being treated by a therapist, the therapist can weigh in on the relative bond between the child and the biological parent and compare that with the bond that the child has with the step parent. and discuss any concerns that the child has or damage that's been done to the child-parent relationship between the child and the non-custodial parent. One of the things that I have my clients do is I have them build a chronology of events. Date on left, event on right. Date on left, event on right. And I have them go through the history of all of the problems that have occurred with the non-custodial parent and how that's impacted the child's relationship with that parent. And I also have them describe all of the ways that the child has been benefited by their relationship with the step-parent. Describe that bond. Things that get added to the chronology as exhibits, other than just from the parent's memory, include social media posts, text messages, emails, but they can rely just on their own memory if they don't have any other data. We sometimes interview witnesses. I mean, there are grandparents or friends or family members that have witnessed these same kinds of things, and we would interview those witnesses and put their testimony down into an affidavit or declaration. Sometimes I have clients who will record conversations and then do transcripts of those recordings. And in Utah, it is legal to record a conversation so long as you're part of it, whether it's in person or over the phone. You can also engage in what's called paper discovery to help bolster your case.
So what is that?
Paper discovery are methods by which attorneys can find out information. One that you might be familiar with is a subpoena. So we could subpoena bank records or criminal records, therapy records in some cases. You also get 10 requests for admissions. Generally, it's 10. Requests for admissions are a document you send out to the other side saying, please admit X, please admit Y, please admit Z. And they have to respond within 28 days. If they don't, then everything that you ask them to admit becomes truth for purposes of the case. Examples might be, please admit that you had no contact with the child between this date and this date. Please admit that the child's relationship with the step-parent is a close parent-child type bond. Please admit that between this date and this date, you only contacted the child 3 times via text or whatever. And they have 28 days to either admit it or deny it. And it forces them to have to show their cards quickly on that issue. You also get interrogatories. These are open-ended questions you ask in writing, and they have to respond within 28 days. Please tell me all the methods by which you have tried to support your child financially for the last 2 years. Please tell me all attempts that you've made to have contact with your child between this date and this date. Please tell me all the reasons why you didn't have contact between this date and this date, and or whatever, any 10 open-ended questions, and they have to respond within 28 days. You get 10 requests for production of documents. These are like 10 subpoenas on the other side, and they have to provide the various records that you ask. Please provide me all of your bank statements between this period of time and this period of time. Please provide me all police reports involving you between this date and this date. 60% of the answers that you're going to get back are going to be garbage. When that happens, you can file a motion explaining to the court, here was my request, Judge. Here was their answer. It's completely insufficient, or they failed to answer this part of the question, or they failed to provide this document. Please force them to do so. And the court will look at that motion and make a decision. And very often you'll get much more information after you bring it to the judge's attention, how they've attempted to avoid answering X, Y, and Z. Another more powerful form of discovery, though, is expert discovery. And there are treating experts, like the child's therapist, and then there are forensic experts that you can hire. These are generally psychologists that you can hire to do a best interest evaluation, a termination adoption evaluation, to pore over all the data, do psychological testing, do interviews, and render an opinion to the court as to what is in the child's best interest. Using a forensic evaluator can be extremely powerful. And if the evaluator looks at the relationships and says, here's what I think is in the child's best interest, it's pretty hard to overcome that. If a treating therapist also testifies about similar things, that can also be extremely powerful. Another powerful form of discovery that attorneys can use is a deposition. What if I were to send a notice to the other side saying, you are required by law to show up at my office at this date and time. where a court reporter, a stenographer, will be waiting and will put you under oath to tell the whole truth. And I'm allowed to ask you questions for up to 7 hours. Pretty hard to avoid 7 hours worth of questions. And so even if 70% of their answers are garbage or attempts to avoid answering, 30% of a 7-hour deposition is a lot of significant data and answers. And that can be a very powerful way of getting information to help prove grounds and best interests.
So Kelly, once you're done with the discovery and the deposition, what do you do with all that?
All of the data that you gather during the course of discovery, you plug that back into your chronology, hopefully use that at the deposition. And then how do you use the deposition? Well, you highlight the good stuff. If there are answers that are helpful to help prove your case, you highlight that stuff, and you then provide that information to the forensic evaluator, if there's a best interests or termination evaluator, which gives them grounds upon which to base their opinion. Or back to the therapist and say, hey, well, therapist, in conducting your therapy, it is helpful to be informed by collateral data. And so here's the deposition of this guy to help inform your treatment, help inform the therapist's testimony at trial. The other thing you do with the deposition is you use that to form your questions at trial. Remember how I told you you highlight the good stuff? Well, what questions do you ask the other side at trial? Only the highlighted stuff, because then that makes your examination or cross-examination of that person extremely powerful. Every question is a zinger. And if they deviate from their answer this much, then you can confront them in open court with their deposition transcript and show that they're a liar.
I'm here with experienced family law attorney Kelly Peterson, who, where appropriate, helps terminate the parental rights to allow for step-parent adoption where the non-custodial parent has abandoned, abused, or neglected a child. If this is an issue that you or a loved one that you know struggle with in Utah, don't hesitate to contact Kelly Peterson's office to see how he can help. He can be reached at www.kmpetersonlaw.net.